In contracts, one or both parties' duty to perform might be conditioned on the other party's performance. But what if one party offers or tenders performance and the other rejects performance as a means of evading its own obligations? We explore the intersection of conditions and tenders of performance in Brinton versus Haight. When G.W. and W.D. Haight purchased land from James and Patricia Brinton, the Haight's executed a promissory note requiring monthly payments. The note was secured by a deed of trust, which transferred legal title to the property to a trustee, Pioneer Title Company, pending the note's payment. Pioneer was also the escrow holder and therefore received payments on the Brintons' behalf. On November 9, 1990, G.W. Haight tendered a cashier's check to Pioneer for the note's payoff amount, which included outstanding principal and accrued interest. But when Haight requested a reconveyance deed, transferring title back to the Haight's, Pioneer informed him that the deed couldn't be issued immediately. Haight took the check back and said that he would provide it again once Pioneer prepared the deed. The Haight's then realized that the payoff amount included a $28 reconveyance fee, which they believed they weren't liable for. Consequently, they informed Pioneer that they remained ready to provide a cashier's check for the payoff amount, but not the reconveyance fee. Pioneer refused to prepare a reconveyance deed without the fee, and the parties reached a stalemate. Because the Haight's were no longer making monthly payments, in June of 1991, the Brintons sued the Haight's to recover the outstanding principal plus interest through the judgment date. The Haight's conceded liability for the principal, but argued that because of the tender of full payment on November 9th, they weren't liable for interest after that date. The Brintons countered that the tender wasn't valid because it was conditioned on Pioneer's issuance of the reconveyance deed. The district court held in the Brintons' favor, and the Haight's appealed to the Idaho Court of Appeals.